Hey, it's Amy Pittman. Again, we're talking about our Basics of Estate Planning series. This document that we're talking about today is going to be the Durable Power of Attorney. A lot of states call that the same thing. I will say Florida's Durable Power of Attorney is going to look a little different. In 2011, they basically added the entire statute to the document. It's very extremely detailed. It lays out all the powers that your agent will have for you while you are alive. So in Florida, our durable power of attorneys are effective from the time you sign it until you die. So that means if I give my durable power of attorney to Josh, he can start acting for me. He probably doesn't want to, but he could. Now, if I'm not naming my spouse, maybe I'm naming a friend, I'm not going to give them that document because they don't need it right now. I'm going to make sure that that person that I name knows where to get the document and who my attorney is, but I'm not actually going to start providing them with documentation just in case I change my mind. And we know that people are changing their minds. People have falling outs with family members or friends. And it's just so much easier if you still maintain possession of that document. So a durable power of attorney is going to name someone to be in charge of you and your day-to-day affairs and any asset that's in your individual name. That person is called an agent. Some states call that an attorney in fact. So as my agent, they're basically standing in my shoes and they're being me. They can't vote for me, or at least legally vote for me, and they cannot sign a will on my behalf. But they can sell my house, they can sell my car, they can do funeral arrangements, they can deal with my pet, our dog Bailey, they can do anything with my retirement accounts, they can do anything with my business, they can act for me for my behalf. So I don't want to just name anybody. I better make sure that the person I'm putting in this position can be trusted, can be timely. Because if I'm incapacitated, they got to maintain me. They're not making disbursements to my beneficiary. That is when we're dead. But power of attorney is while I'm alive. Who's actually making my financial decisions, making sure my bills are being paid? Well, we don't list in that power of attorney what those bills are or your passwords or those assets. So it's very important that you create a list of your monthly expenses. How do you pay them? That list of your assets, are they owned by you or if they're in your trust? Because if you have a revocable trust, the durable power of attorney does not control assets that are owned by your trust. The durable power of attorney is giving power to the person that you named as your agent, which may be the same person that you put in charge as your trust as trustee, but it's not always the same. So that durable power of attorney is allowing that agent to do anything for you that's personal to you. So again, that's an asset that's in your name alone. So if the house just says Amy Pittman, it's my power of attorney agent that would sell my house. If I'm alive and unable to act, that's usually when they're stepping in. But again, it's effective as soon as I sign it. So if I give it to my friend and they decide they want to start canceling my cable or my internet, they could do that, and it's really going to be up to the company that they're going to on my behalf, whether or not that company goes, what's wrong with Amy? Why is she not talking to us? And they're probably going to ask for the copy of the document. So they're going to have the document to act. And then if they're trying to do something with my IRA or my bank account, most financial institutions will ask for a doctor's statement saying I'm unable to handle my affairs, but they're not required to. Again, Florida says our durable power of attorneys are effective from the time you sign it until you die. Once you die, it is no longer valid. So if someone is on my account as my power of attorney agent, once I die, that access, that control, that power is gone. So hopefully there's a beneficiary on that account if it's an asset so that my beneficiary gets it when I die. But again, that power of attorney is basically doing everything that I can do for myself. And I cannot stress, this is the most important document we have in our estate plan. It is the most used. It is allowing this person to be me when I can't be me for myself. And it could be temporary, right? I could just be incapacitated, having a medical issue for, a couple months. Or it could be long-term where I have an issue where I'm in an assisted living or memory care for years. So definitely make sure that you pick the right person and you revisit that person that you named to make sure that's still the right person for you. And again, I don't want to give it to them, but I do want to make sure that they know that they've been named. Because they could say, no, I don't want to do that. Because it's a large ask, right? It's a big ask. So you're putting a lot of responsibility on this person. And sometimes They may say yes now, but in 5 years, their situation looks different and maybe they can't do it for you. And we don't want to just name anybody, because again, this is extremely powerful. They have access to all your assets that are in your name. They can pretty much do anything that you can do for yourself. Now, there are some exceptions to that, which we go over with our clients. Florida has what we call superpowers, where we can say yes or no to those powers based on who the client is naming as their agent. So again, as part of an estate plan, you have your incapacity documents. We've gone over the healthcare surrogate, the HIPAA, the medical release. We've gone over the living will, and now we've gone over the durable power of attorney, which is the financial day-to-day while I'm alive, naming someone to be me when I can't. All right, hope you enjoyed. Have a good one.